since the beginning of COVID, I have seen personally, and I think Tony can probably tell you the same thing, more non-compete and non-solicitation cases come across our desk than in the 20 years that I had combined before then. And that is significant because it seems like every week we get one at least where we're either helping someone who wants to hire somebody but has a non-compete or non-solicitation or a confidentiality agreement, or we're going after somebody who went down the street and wants to compete. And so we've seen a ton of these lately. We're seeing them go more. There's been some changes. So I want to kind of turn first to Rob and say, Rob, good morning. Thank you for joining us here and for everybody out there.
Good morning, Cliff. Thank you for having, and thank you everyone for attending today.
Right. So, can I ask you to start it off? What's the difference between a non-compete agreement and a non-solicitation agreement? They sound pretty similar. What's the
Sure.
difference in those two?
Sure. And as you said, we've been getting more and more calls on these sorts of topics, and having a clear understanding of which avenue you want to go down, or even both, is a really good starting point in order to figure out, how you can protect your legitimate business interests. So, first of all, a non-competition agreement is a restrictive covenant that a person would sign that basically says, hey, I agree that I am not going to, if it's drafted correctly, directly or with someone else, right? Engage in activity that competes with your line of business, right? Has to be within a certain geographic scope, has to be within a certain timetable, right? And it has to be reasonable. And we'll kind of get into those tests and those requirements later on in our conversation. But you can think of the non-competition as the broad restriction. Hey, you know what? I taught you how to do XYZ, or I have a secret formula in how to do XYZ. I have a special way of putting mayonnaise on the bread, is what Jimmy John's argued, a few years back when they tried to enforce a non-competition agreement. But it's basically restricting someone from operating within that industry. Okay. Or excuse me, non-compete basically restricts someone from operating in the industry. A non-solicitation agreement is a little bit more narrowly focused, right? What that says is, hey, you know what? You can compete in the industry, but you're not going after my clients, my employees, my vendors, right? Whatever happens to be included within that scope of that particular agreement, right? So non-compete is that very broad restriction. Hey, I'm not, you're not allowed to be in the industry at all. Find a new career. Non-solicitation means, yes, I'm going to allow you to operate within the industry, but my client listed all the people that you knew about, you can't contact them, right? And how you describe that becomes a very interesting topic, right? Because let's say you have a non-solicitation agreement. You say, hey, you can't contact any of my existing clients, now or in the future. Well, are you going to keep the person up to date with your entire client book on an ongoing basis, right? I mean, how do you navigate those sorts of issues? And those sorts of items are what we're going to be talking about in a little bit more detail today.
So just kind of off the top a little bit for people that aren't familiar with these things, I just have a question for you. If I have an employee and they're a pretty good employee and they know all my other employees and they know who's good and they know who's bad. And let's just say I don't have a non-compete against them. They can go work for my competitors or anywhere down the. Is there a way that I can say, well, if you go get my customers, then that's on you and whatever. But can I stop them from taking my employees with them, the good ones? Can I write something in a agreement like a non-solicitation to stop that?
Yeah, I mean, look, there's what you're talking about is basically like a no poaching provision, right? You're not going to take my employees, you're not going to bring, people over. And yeah, can you use a non-solicitation agreement for it? Maybe, right? There's certain, enforceability questions. It also begs some antitrust questions depending on the size of your company. The agreements that say, hey, you know what, you're not going to hire my people may invoke antitrust issues depending on the scope and duration and the size of the company. But yeah, I mean, restrictions on, going after existing employees, going after existing vendors, things like that is a fairly common use of non-solicitation agreements.
So you've got your don't compete against me.
Hmm.
You've got your don't take my customers and clients, right? Because you have the inside knowledge. And then you have the maybe don't poach some of my employees. So, under what circumstances would one agreement be better than the other?
Sure. Well, I think it's a business by business analysis, right? It's also a provision by provision analysis, right? I think every person in the world would say, hey, an agreement that my employees sign that they will never compete with me, they will never solicit, they will never do anything to harm my business for the next 500 years is the best thing that we could ever hope for, right?
Mhm.
The reality is it may not be enforceable, right? So you have to really look at your business and what you are trying to protect, right? If you have a business that has very highly technical information, particularized processes, things that aren't, generally commonly known, especially if you're training people, right? And again, assuming you have reasonable restrictions, right? It has to be tied to the scope of the business, where you're operating, how long, and assuming that those boxes are checked, a non-compete agreement generally gives a little bit broader protections for a company. On the other hand, if you have generic processes, we always talk about the Jimmy John's example, right? When they tried to enforce a non-compete agreement for people that were, making sandwiches and putting mayonnaise on bread, right? A non-solicitation may be a little bit more likely to be enforced. And again, as we'll get into, the courts view the enforceability of the agreements a little bit differently. So it really does need to be a company by company analysis, a business by business analysis. And then there's also market conditions, right? Finding good help is hard. And people that are in high demand know that they're in high demand, and they may have some negotiation leverage to say, hey, you know what? I'm not going to sign a non-competition if you want me to come work for you. I don't want to be barred from the industry, or I don't want the risk that I'm going to have to fight this later on. I'll agree not to go after your people, right? But I'm not going to agree to be out of the entire industry if I decide to leave your employment. And the other
And
thing
that's a good point,
is,
though, right?
yeah,
I mean, you just said, I think hit the nail on the head. It's the market conditions. In
mhm,
'07 and '08 here in Michigan, I mean, people were begging for a job. People were being
yeah,
laid off. We had an outrageously bad economy where people were looking for jobs, moving out of the state. During COVID, one of the reasons why I said that we have so many is probably because of the fact that people were being paid to stay home and could
yeah,
work from their nice cottage up north or Florida or whatever. And we're like, yeah, maybe I won't come. So there was a need to try to protect the employees and try to get these enforced as they are. Now we're where we're at now. And so it may have changed, but you did
correct,
right. It changes
correct.
now,
And
right?
and also understand, the agreements aren't mutually exclusive, right? It's not uncommon, especially in some of the business work that I do in the transactional work, to include both a non-competition and a non-solicitation provision, right?
Yeah. So we can mix and match or a
Hmm.
little bit, right? Okay. So when, Rob, can you ask an employee to sign a non-compete or a non-solicitation? When can you do that?
Well, you can ask them to sign it anytime you want, right? Whether or not they will or it's enforceable are two different things, right? So, typically speaking, we see non-competition, non-solicitation agreements being solicited at the start of employment, right? It's part of the standard agreements, or it's part of the negotiation package, right? You can also see those arise, based on fundamental transactions, right? If the company's bought and sold, right? People may have updates and refreshes to the employment agreements, right? You can also see it on the exit side. We're going to get into separation agreements later on in today's session, right? But as a condition of separating from the company and getting X number of dollars, it may be an appropriate position, right? Courts have said that continued employment is sufficient consideration, generally speaking, for
Even at will?
even
Even
at
at
will.
will?
Yeah.
Okay.
Yep. Yeah, sufficient consideration for the enforcement. Now, obviously, facts and circumstances. There's very few safe harbors and very few bright lines, right? I'm sure that a court is going to look at the agreement a little differently if you had them sign the non-competition in the middle of their employment and 30 seconds later you fire them afterwards, yeah, may have a little bit of an issue with enforceability under the facts and circumstances. And Tony will talk about that here in a little bit. But again, you could ask an employee to sign the non-competition or non-solicitation agreement at any point in time. Whether they will, that's a different story.
Right. Okay. Well, thanks, Rob. I got a question for you, Tony, just to jump in here. And it's an interesting one about how can a non-compete be challenged, right? So we have lots of business circumstances, like Rob was talking about why you draft it. But what are some of the things that you're seeing, that you've seen, that are out there where people can say this non-compete and this non-solicitation is not worth the paper it's written on? What are we looking at for those type of issues?
Yeah, and as you and I both know very well, these agreements can be challenged, and they are frequently challenged all the time. Now, what that means, whether it's a lawsuit, whether you get a nasty letter from either side saying, hey, I've got this non-compete, you jumped across the street, you're ruining my business, or hey, you made me sign this non-compete. It's not enforceable. You're prohibiting me from making a living. It's overly broad. It's not reasonable. There's arguments on both sides of it, but they are frequently challenged all the time. And I think a year ago we were yelling from the rooftops, "Hey, this FTC rule,
Yeah.
watch out! Non-competes are going to be banned." Well, that was struck down by a Texas district court. I think the FTC has appealed that. So they're still in litigation. That FTC rule is still banned, which means that in Michigan, non-competes are still enforceable. That being said, again, as you know very well, Cliff, there's a sort of practical side to it too, and judges look at non-competes very differently, depending on the facts and circumstances, like Rob mentioned. So, in general, Michigan courts apply a rule of reason. So, under Michigan statute, restrictive covenants are enforceable only if they're reasonable, and that word does a lot of heavy lifting. So, the courts will look at four things. They'll look at, does the employer have a reasonably competitive business interest worth protecting? So is that trade secrets, specialized training, confidential information, customer goodwill? It has to be something more than just avoiding competition and preventing someone from going down the street. So that's number one. Number two is the duration reasonable? So is it a non-compete for 6 months or a year or 2 years? Or is it 10 years? I'll tell you, I think courts would probably strike down a 10-year non-compete. The third is the geographic scope tailored to where the employee actually worked and where the company does business. So again, kind of looking at the big picture. If you're a sales company and you've got a national presence and you've got sales executives working accounts all across the United States, a non-compete that has a nationwide scope might be reasonable. If you're a Michigan car dealer, for example, and you work within a 15-mile radius, a national, non-compete probably isn't going to be enforceable. And then the last thing is the type of work or the line of business that's being restricted. So do you write in the agreement, hey, you can't work in the automotive industry, selling, manufacturing, whatever, or is it just so broad that you're preventing someone from working in that industry at all? So these are the things that courts will look at when they assess the reasonableness of a non-compete. And courts can blue line the agreement, so they don't have to throw the whole thing out. They can rewrite it essentially, to make it more reasonable. So to answer your question, yes, they're enforceable in Michigan. That's what the courts look at. They're challenged all the time, but the analysis is very fact intensive and depends on the situation.
So right now, I think you hit the nail on the head, though. There was last year when we were talking to clients, there was a federal law or a federal rule that was coming out from the Federal Trade Commission that was effectively going to ban most non-compete agreements. That's not happening right now, and it probably won't be happening anytime in the near 3 years while the current administration's in there. Could happen, but most likely not. I've heard there's a law that's pending here, a bill that's pending in the state house. That's not going anywhere, I assume, if they can't figure out how to pay the bills.
Every single year they introduce that bill.
That thing's coming. There's a bipartisan bill at the federal level that I understand was put in there, but again, our friends in Washington don't always get along. But who knows, right? It could be coming down the pike. But as we sit here today, if you do a Chat GBT search and they say, "Oh, don't worry about it, it's not enforceable," that's not accurate. We're telling people today that in Michigan, as long as it hits that rule of reason, then they are enforceable unless they hit those factors. And Tony, you can say practically, we know this. What judge you get does make a difference in enforcing, isn't that?
Oh, yeah.
Your
Oh,
understanding?
absolutely. And, I think we'll get to it in a second, but, a lot of times what happens in these cases is if it's really serious and someone's stealing customers and they're stealing your employees and they're out there, we'll get calls from clients all the time that say they are ruining our business and we have to stop them now. And so what you typically do is you file a temporary restraining order and you seek an injunction asking the court to enter an order saying either that person will stop working for a competitor or they in order saying they will not solicit our employees, they will not solicit our customers anymore. And judges, they're skeptical. You really got to have the facts on your side to show, this person is ruining and will ruin our business. You got to be able to show that they're either taking your confidential information, they're taking your trade secrets. So again, it really depends on what judge you have. Cliff and I have had judges that say, absolutely not, get out of here. I haven't granted one of these in 20 years. And then other judges will look at him and say, well, it's, here's a contract. You breached the contract. Here you go. So it kind of depends. And, there is a sort of equitable element to it as well. For example, I think courts will look at, are you preventing someone from earning a livable wage? Is it a rank and file employee or is it an executive? Is it someone who's worked in that industry for 30 years and this is all they know and now you're preventing them from working in that industry? Or, is someone who's bounced around a lot? So these are some of the things that the courts will take into account. And I was reading yesterday as well, courts will also look at the circumstances that someone leaves. So in most cases, an employee quits and then they go across the street the next day. But there have been some cases where a company will fire an employee and then go and try to enforce a restrictive covenant against them, saying that they can't go work somewhere else. And again, kind of to the equitable things that the courts look at, a court said, nah, I don't, there's some off there that, you fired them and now you're trying to enforce this against them. So the courts have some discretion. These are some of the things that they look at.
So Tony, I want to talk a little bit about it though. When you were going through this, just so everybody here understands what we're saying. One of the things you can do when you try to enforce these is to run to the courthouse and not just file a lawsuit, but you could ask a judge to say, look, I don't want you to decide the case quite yet because I know there's a process. We got to go through a court case and litigation. But things are so darn important here. We're going to lose the business. You can't undo it with money. We need you to not have the dam burst and flood the town and kill everybody in the town. We need you to put a stop to this now. That's one thing you can do, but doesn't that require a little bit more than just saying we're going to win?
Absolutely. So what you have to do when you go to the court, and because it is such an extraordinary remedy that, at the beginning of a case, you're asking the court to stop someone from working or enter an order that they can't do something. The court requires two things: success on the merits, so meaning, are you going to eventually win your breach of contract, your breach of the non-compete or the non-solicit? And you have to show irreparable harm, which means you need to show the court that money damages alone aren't going to make you whole. You have to show that, I'm going to lose goodwill, I'm going to lose reputation, I'm going to lose my trade secrets that I've spent all this time and money on on developing, you're going to have to show the court that, money isn't enough. I need an order now stopping this person from doing these things. And it is a high bar. And so, like you said, Cliff, you typically run to the court and you're asking them to do this. And a lot of times it's the sort of critical point in the litigation, because if you lose and the employee is permitted to just keep working there and keep doing what they're doing throughout, 2 years of litigation, the concerns might go away, or, the damage might already be done. So it's a huge part of it.
So just to make sure, 'cause, we could sit here for hours, honestly, and talk about this, which you and I have done on a number of cases. But strategically, sometimes you don't go to the judge and ask to stop it right away because you're not going to meet that bar. There's going to be the ability to get the money at the back end. So you could lose an injunction, still win the case. We can draft agreements in ways that help us, that make sure that it's clear on what we're going to get and how we're going to get this as far as damages and things of that nature. But yeah, it's a process, right? We draft them the right way. We look at the market conditions. We understand there are rules, there are defenses. So whether you're trying to enforce or not enforce, we look at the things you just talked about. But at the end of the day, I remember there was a show called The Office, and the boss came in one time and he yelled in front of the office, "I declare bankruptcy." But that's not how you do it, right? Same thing with drafting an agreement. You can't just simply say, "Hey, everybody, you can't compete, and you can't solicit our people." You got to do something. You got to put it in writing. And so, Rob, just to kind of finish up this topic, what's the best way to draft agreements for enforceability? What are some things we can look at?
Sure. Sure. So number one, we have to acknowledge that what's enforceable on day one may not be enforceable 5 years into the growth of your company, right? So understand this is not a check mark one and done and is a universally acceptable issue, right? I mean, you can set some standards and things like that, right? But if you have a legitimate business concern, you really do want to tailor to the extent you can those agreements, right? What may be a legitimate duration or a legitimate area for person A may not be for person B, right? So, again, when you're negotiating, things like salary, things like compensation, those sorts of things that vary, you should also keep in the back of your mind, excuse me, the restrictive covenants that you're going to be asking, because we may want to alter those, right? So again, reviewing that on a case by case basis for, the enforceability items Tony brought up. Two is, as the company evolves, do there need to be changes, right? Three, when the company engages in certain transactions, do we need to reevaluate those? And that may also, come naturally, right? So those are some things you want to think about as far as timing, right? But if we're talking about provisions and actual drafting for enforceability, right? Some things that you want to have is, the blue line or blue pencil language that Tony was talking about. Yes, is there a statute that allows the court to do it? Yes, MCL 455 744 allows the court to always modify the contract, right? But having language that says, if the scope or the duration or the area, whatever factor is unreasonable, parties agree that the court may modify it to the largest possible duration, is certainly a good arrow to have in the quiver, right? If there's a challenge in the future, right? Documenting how you came up with the reasonable scope and durations, right? If you're trying to use a nationwide area for the non-competition agreement, being able to document within the four corners of that agreement why we've selected that area, right? So that way you don't have to show that extrinsic evidence in order to justify it, right? And then also just making sure you have good language, right? We've seen this before time and time again. You have non-competition agreements that are just, off the shelf, one paragraph with one sentence in it saying you're not going to compete, within 500 miles of us. Well, what does that mean, right? You're not going to compete in one areas, right? Tightening up that language and having that bespoke provision is certainly something that will help with drafting. And Cliff, as you said, I mean, we can talk about these things for the next 6 hours. Unfortunately, we don't have enough time to do that. But again, focusing on making sure that those elements that Tony was talking about was met is your best bet in drafting.
Okay. Well, hey, I appreciate it. Thanks a lot, guys. A lot of information.
Sure.
If you have any questions, I ask everybody just to reach out to us, let us know, because it's not a cookie cutter situation. There's opportunities whenever you hire, whenever you have mergers, you have sales, you have acquisitions, you're redoing your handbooks, you're looking at policies. It's a Wednesday, whatever. There's always opportunities to update your agreements, and you should. So thanks a lot. Appreciate it.